everyone for coming to this seminar of the Oxford Jurisprudence Discussion Group. Um, we have a very special seminar today, um, a book symposium, right, to celebrate the recent publication of Leslie Green's The Germ of Justice, right, OUP 2023. Which contains 14 essays in general jurisprudence by Leslie Green. He needs no introduction, but I'll just say that he's emeritus professor of philosophy of law here in Oxford, emeritus fellow of Balliol College in Oxford, emeritus professor also in the Faculty of Law at Queen's University in Canada. We want to thank, of course, Les for doing this, for joining us from Toronto, Canada. And also we want to thank the three commentators we have with us today, Julie Dickson, Tom Adams, and Nicos Stavropoulos. And also we want to thank Tom Adams double because he sort of helped put this together. He acted as liaison between us and Les, who's bad for replying emails. All right. So the way we're gonna do this is that we're gonna start with the comments. So Julie Dickson first, then Nicos, then Tom, and then we're gonna hear some remarks from Les Green himself, and then we'll have a Q&A. Right. So do let me know, raising your hand by the end of the session, whether you want to ask a question. All right. Without further ado, I'll give you Julie Dickson.
Okay, so good afternoon, everyone here and everyone online. So many wonderful colleagues and friends to see here, which is a wonderful feeling. And a big thank you, of course, to the JDG organisers for inviting me to be one of the commentators at this event on Professor Les Green's wonderful, newly published book of essays, The Germ of Justice. Like many of us, I'm sure, I've encountered, read, puzzled over, returned to various of these rich and insightful essays over many years, and seeing them all gather together in this book, along with some new material written specially for it, I have a feeling akin to seeing lots of wonderful and familiar old friends all coming together for a kind of reunion or a party. And happily, unlike what sometimes happens, at least in my own social experience, with actual friends and actual such gatherings, these essays do not sort of stand around awkwardly, not sure how to talk to one another, hoping desperately that alcohol will soon kick in to make things bearable. Rather, in the case of the old friends' essays gathering together in the Germ of Justice, their communing feels very natural. It enables the reader to see and engage with many echoing, interweaving, cross-pollinating puzzles and themes that infuse Les's work and give it such richness and depth that it's no wonder we return to these essays again and again. And like all of Les's work, and of course like Les himself, the essays in this book are also full of such wit and thoroughgoing good humour that they definitely don't need to wait for the alcohol to kick in to get along and to show their wonderful qualities. As I've already told Les, I particularly liked one line in his book about Kelson struggling to unfankle something. Scottish thing, can explain later. Okay, so what I'm going to do is I'm going to comment here on just 2 points from the book. One is about the notion of progress that is apt for the philosophy of law, that Les discusses explicitly mainly in the introduction to the book, although it's implicit in much of the rest of it. And the other is a point of Les's that I'm strongly drawn to as well, which appears in various guises in various chapters of the book, particularly the introduction in chapters 3 and 7, and it's the point about law's necessary vices, about law's internal vices, the immoralities that law makes possible. It's a quote from page 11 of the book. Okay, so progress, first of all. In the introduction to the book, Les has a really interesting discussion as regards whether there has been and in future can be progress in legal philosophy, and indeed what sort of understanding of progress would be apt for our discipline. And he picks out three possible marks of progress apt for legal philosophy: shrinkage, convergence, and understanding. And it's the third of these, understanding, that I want to ask Liz something about. So at one point in discussing this aspect of progress in legal philosophy, Liz says, this is on page 20 of the book, a final mark of progress is a deeper understanding of jurisprudential problems. He also says further down page 20, over onto page 21, there's also progress in finding new problems or seeing new aspects of old ones. Discovering a problem most failed to appreciate is another kind of progress. Now, my interest in this topic is quite a bit of self-interest, in the sense that thinking about which questions philosophy of law ought to tackle and what might count as progress as regards approaching these questions is something I've tried to write about in my own work. And I remember that on more than one occasion when I was presenting some of that work, when it was work in progress, and Les was in the audience, that Les seemed to slightly take issue with the idea that I've sometimes put forward as well, that coming up with more and better, deeper, under-attended to questions, not just the answers to those questions, that generating those better questions could be a mark of progress in legal philosophy. Surely I took Les then to be saying, sometimes heckling from the back of the room, not kidding, that it's about the answers, getting the right answers to questions that counts as progress in philosophy and legal philosophy, not just the coming up with more different new questions. So my first point is just I wondered whether Les would regard his views in this respect as having changed a little, perhaps so that now for Les, and I presume he would recommend for all of us, generating novel, diverse, perhaps under-attended to questions is as much a marker of what counts as progress as getting the right answers to those questions? Or would it be going too far to say that the novel and better question grasping is as much a marker of progress as getting the right answers? And or another possibility that I think I should have been better explaining in my own work, which is that perhaps the separation between understanding and generating questions on the one hand and getting the answers to them on the other, that this way of putting it, that I'm putting it, seems to imply that maybe that's misleading, and that in various senses, generating novel questions and new ways of looking at puzzles about law is itself part of gaining new understanding of aspects of law. So that on that view, progress would be something more along the lines of moving towards novel and deeper questions and answers, where those are not so separable as is it about generating the better questions or about getting the right answers to those questions? So that's my first point about progress. The other issue I wanted to mention is this business that comes up a few times in Liz's work, not just in the Germ of Justice, it also features in his wonderful introduction to the third edition of A Concept of Law. This business about law's internal vices, the immoralities that law makes possible. So, as well as the quote, that's a quote, law's internal vices, the immoralities that law makes possible, that I've just mentioned. In the introduction to the book, Les also says, some jurisprudence, I did wonder at that, jurisprudence, surely the term is jurisprudence, I wondered, Les, but anyway. Some jurisprudence spends so much energy prospecting for and then burnishing a nugget of necessary goodness that they neglect the possibility that it's also in law's nature to bring special forms of evil into the world. And in chapter 7 of the book, The Inseparability of Law and Morals, when Les is discussing various necessary connections between law and morality, he says also, it's a curious fact that almost all theories that insist on the essentially moral character of law take law's character to be essentially good. The gravamen of Fuller's philosophy of law, Fuller's philosophy is that law is essentially a moral enterprise made possible only by a robust adherence to its own immorality. The thought that law might have an inner immorality, says Les, never even occurred to him. And I think Les and I agree here about this curious fact and about the fact that it isn't just confined to Fuller. To me, it seems that a surprising number of those who think that law has an essentially moral character seem to take law's character to be essentially good. And I sometimes find myself asking, why does it always come out positive for these theorists? Are they living in the same world and legal world that I am? Or as Hart once memorably put it in responding to Dworkin, why not show it in the worst light? Law. Anyway, happily Les is here to balance things up, to direct our attention to the possibility that necessarily law is morally risky and makes possible new vices. One of these, he argues in chapter 7, is, quote, the risk that ordinary subjects will be alienated from the rules that govern their conduct. It's page 193 of the book, and he continues on that page. Wherever there is law, new moral risks are unavoidable. There are not only more efficient forms of oppression, there are also new vices. The alienation of community and value, the loss of transparency, the rise of a new hierarchy. So for Les, and I agree, because legal systems are necessarily institutionalized normative systems administered and enforced by a professional class of legal officials, law by its nature always and inevitably runs the moral risk of becoming distant from the communities it regulates, such that those communities become alienated from law and regard it not as their law, but as something remote, technical, intransparent, even as it governs some of the most important aspects of their lives. So I agree with all this, but what particularly captured my interest in thinking of what to say for this comment was this statement from Les, and it's on page 194 of the book. He repeats the point I just mentioned. Les says, although law has necessary virtues, it also has necessary vices, and this marks a connection between law and morality of a reverse kind. There are moral risks that law's subjects are bound to run, and they are risks against which law itself provides no prophylactic. Okay, so I'm interested in wanting to ask about two things here. One is whether, in Les's view, whether the same features of law, or perhaps certain aspects of the same features of law, can they simultaneously contribute to law's necessary virtues and to law's necessary vices? And the second thing I want to ask about is, even if law itself can provide no prophylactic against the risks instantiated by its necessary vices, where those vices are in the form of risks rather than actualized realities, I wondered whether he thought anything else can hope to act as a prophylactic against those risks, and in particular whether there's a role for legal philosophy, broadly understood, to consider what, if anything, might help to lessen those risks. And 1 and 2, I think, are linked because, for example, if one and the same feature of law contributes to law's necessary virtues and law's necessary vices, then it might be especially challenging to lessen the risks without removing aspects of the virtue. And it was something in chapter 3 of the book, the essay on custom and convention at the foundations of law, that alerted me to the possibility that Les might think that one and the same feature of law could be contributory both to its necessary virtues and to its necessary vices. Because in that chapter, Les says, when he's discussing the character and relevance of consensus and recognition practices in legal systems, this is page 86 of the book, he says, whatever the merits of a broader consensus, law can work untethered from the views and values of the community it regulates. This is the downside of a feature that contributes to law's value. Law's institutionalized nature allows officials to create new norms for a society in advance of, and therefore in the absence of, social buy-in. And parts of that idea that law can lead, that law can be out ahead of wider societal attitudes, shaping and changing them, is also discussed by Les in chapter 10 of the book, Should Law Improve Morality? Which, by the way, is just on its own a terrific essay with enough richness for a whole evening full of comments all on its own. Anyway, so it sounded to me as though the division of labour that Les holds to be a necessary feature of law between legal officialdom on the one hand and those subject to law on the other is simultaneously contributory to one of law's virtues, that it can be out ahead of, differ from, shape general societal opinion, and that which contributes to one of its necessary vices, law being necessarily morally risky, and having the potential always to become remote from and alienated in terms of the community it governs. So I just sort of wanted to check that I got that right, that Les thinks that one and the same feature of law can be contributory both to law's necessary virtues and law's necessary vices. And then to ask Les, the second part of this part of my question, if that's the case, do you think there's any role for legal philosophy, broadly understood, in trying to ameliorate law's moral riskiness? To put things in terms of the example I've drawn attention to from Les's book. Can we get the good lobbying out ahead of, able to shape for the better societal attitudes that are somewhat divorced from it, without the bad, the vice of alienation, remoteness, people feeling so far from and not having a stake in the most important norms, some of the most important norms that shape their lives? Or if we can't get the good without the bad, as is sadly the case so often in this life, can we at least try to find ways to lessen the risks of the bad? And again, does Les think that's something that legal philosophy, broadly understood, can play a role in? And perhaps even, I'm just thinking as I'm here, whether aspects of law's essential moral riskiness, in Les's view, should shape the way in which we do legal philosophy, maybe shape the starting points that we proceed in our investigations into law. Okay, so those are my points. Just to close, I just want to thank Les personally for his work, more for his collegiality and his friendship, just for making this whole business that we're in so much more fun than it otherwise would be, all of which have just meant so much to me and have done from the time I first met him, about 25 years ago. It was at a social gathering at Joseph Raz's place in New York. Sorry for the name dropping, but it's true. A social gathering where Les single-handedly, or maybe it should be single-fruitedly, refuted the entirety of K. Putnam's semantics as applied to natural kinds by an extended riff on the existence of tomatoes and the reaction to presence of same in a fruit salad. Well, that's a reference so old and so specific that it's possibly only me who knows or remembers what on earth I'm talking about here. But that's no matter, because that, like so much else about Les and his sense of humour, as you can see right here, just still makes me laugh every single time. Thank you.
Capacity to expand our understanding of the subjects that it treats. But it also has to do with the way in which Les's work is so involved in the social world that it discusses. So philosophy is of its nature abstract discipline, involves a sort of paring away of phenomena to understand their essence or their core. I think Les's work reminds us that it is compatible with such constraints for the work of the philosopher to be deeply invested in the social context of that which it treats. So Bernard Williams said that philosophy is a humanistic discipline. I think Les is a humanistic philosopher. Okay, finally, and I'll stop being nice soon, I should say something about the quality of the prose. So these essays are all beautifully written and in ways that are totally in service, I think, to their main aim of deepening our understanding of the subjects that they treat. So some writers dazzle in such a way that you come to suspect that the dazzle's sort of the main point of what's going on, but I think that's never true with Les's work. Les's prose dazzles, but never to distraction. The light instead is used to illuminate both the argument and its object. Finally, I'll just associate myself with Julie's and Nicos's sentiments. You're missed. Okay, on to the substance of the book. So Les is clear from the outset that this book does not contain a philosophy of law. So the essays I'm quoting from Les here don't add up to a jurisprudence, if by that we mean a complex set of ideas from which may be derived the answers to the main problems of legal theory. Well, why? Well, theory building from a basic set of elements both distorts the phenomena and also sort of radicalizes the theorist. So Kelsen tells us that all laws are sanction-imposing laws, to which the response is, well, what about, for example, public powers? Well, these, Kelsen tells us, are not in fact individual legal norms, but rather fragments of legal norms. So Austin claims that all laws are the command of the sovereign, to which is pointed out, well, in some legal systems, we don't have a body sitting at the apex of that system that could be appropriately described as a sovereign lawmaker. And so we must find, Austin claims, sovereignty, not political sovereignty, but legal sovereignty in the people. So in all of these cases, the claims fail, and they fail precisely because they try to build too much from too few in the way of elements. So instead of building grand theories from few elements, Les tells us that we must work in a modular way, deepening our understanding in a piecemeal manner whilst ensuring consistency in our thoughts. So, however, whilst Les does not defend here a jurisprudence, he does write as part of a tradition, and that's the tradition of legal positivism. So this is associated with the idea that all law is positive law, that law is the creation of human thought and action, and it has the content it does because of that thought and action. No norm is a law because it could be law, and certainly no norm is a law because it should be law. So again, quoting from Les here, everything he says that is law because it is made in a way that is recognized as making law. Now, is this claim in a sense sort of tautologous or circular? Well, no more, I think, than the claim that a rule is a rule of the monopoly if it's contained in the monopoly manual. Now, one of many important differences between these two sets of rules is that law is a dynamic as opposed to static system. So its rules are capable of being constantly updated. The monopoly manual, by way of contrast, is a fixed list. And this is accommodated by virtue of the fact that our test for law is, strictly so speaking, a test for the sources of law, those authoritative means that are capable of giving rise to new laws and thereby modifying legal rights and obligations. So Les does not seek in this book to demonstrate this thesis, but many of his arguments either presuppose its truth or work on its implications. And if they are plausible, and that is not only consistent but credible and convincing, then they lend support to the basic truth of legal positivism. Now, not everyone is convinced by this basic truth. Indeed, if we were to judge the state of the discipline by who is writing about what, we might come to believe that it is in fact anti or non-positivist views that are in the ascendancy at the moment. Now, packaged in different ways, the main arguments by anti or non-positivists against legal positivism's claim that law is at base a sort of social phenomena dependent for its content and existence entirely on human acts is that it fails to explain the normativity of law, or, taking this thought to mean the same thing, the way in which law imposes obligations. So perhaps, so the story goes, positivism and its resources are capable of explaining, for example, the way in which monopoly, phenomena like games, phenomena like monopoly, whose standards are clearly artifacts and whose normative relevance is clearly within our volitional control. However, it fails to explain the way in which law's requirements affect our practical reasoning and impose on us obligations. Now, Green, as I've already said, does not seek to demonstrate the truth of positivism. So you will not find in his work here a sort of line-by-line response to the anti-positivist challenge. And to my mind, that's all for the better. However, in an essay first written for this collection, Custom and Convention at the Foundations of Law, Les makes some arguments which we could think of as forming the basis of a response to this set of challenges. And I'm going to explore those in the remains of my remarks. Okay, so the non-positivist argument is that law is at base a normative phenomena and that it imposes obligations. And the idea is that positivism can't explain these facts. So let's separate these two different claims. The question about the normativity of law, he says, is in essence a pseudo-problem and one that the philosophy of law would do well to get away from. The question about whether law imposes obligations is a real one, but he thinks that positivism is capable of meeting this challenge. So I'll talk about each of these in turn. Okay, so first, normativity. So law, Les notes, is composed of norms. For example, it's a norm of UK law that prohibited from selling cigarettes to minors. It's a norm of US federal law that you must drive on the right as opposed to the left-hand side of the road. So, well, what is a norm? A norm, Les tells us, is a guide to belief, desire, action, or emotion. General norms include rules, individual norms include directives. Now, as an aside, I'm not sure norms can be guides to beliefs, desires, or emotions, as none of these are volitional, but certainly norms are guides to action. Now, norms constitute their own success conditions. It's possible, given the existence of a norm, to drive on the right or the wrong side of the road, to comply or fail to comply with the norm. All of this is well and good. But now, if someone were to come up to me and ask not what is a norm, but rather in virtue of what is a norm normative, Les suggests that we should be confused. We can, he claims, I'm quoting from him here, explain the normativity of norms only in the way we can explain the triangularity of triangles. A triangle is a system of 3 points on one plane. Triangularity is nothing more than this property. So it is a mistake, he says, to ask, in virtue of what are triangles triangular? It's a hard sentence. What grounds the triangularity of triangles? Nothing, quoting again here, there's nothing that stands between triangles and their triangularity that could count as or figure in an informative answer to this question. And so, Les argues, nothing stands between norms and their normativity that could figure as an explanation of the normativity of norms. So if we are asked, well, in virtue of what is it that social rules are normative, or in virtue of what is it that legal standards are normative, we should respond by pointing out that social rules are rules and that legal norms are norms. And beyond this, there's nothing left to say. So on this point, I'm in complete agreement with Les. Well, my concern is this, that he himself is tempted to answer the in virtue of question that his argument suggests that we should avoid. Because Green, following Raz, tells us that the existence of a rule is a kind of reason. Now, this fact is meant to explain the sense in which rules guide. Rules guide my behavior because they are reasons, or give rise to reasons that count in favor of some action on my part. The rule drive on the right is, or gives me reason to drive on the right. However, the thesis is also meant, or so I thought it was, to explain the normativity of rules. Rules are normative on this account because they offer reasons for action of a certain sort. However, so is this an answer to the question that we should not answer? Is this an answer to the in virtue of question? Is it true on this account that a rule is normative in virtue of the fact that it is or gives us reason? And if so, this seems problematic because the claim that a rule is equivalent to there being a reason for action of a certain sort strikes me as a controversial view about the nature of rules, certainly not equivalent to the tautology that triangles are triangular. Now, one response is to say that, well, no, it's not an answer to that question. We should instead take this thesis as explaining what is a norm, because Les suggests, and I agree, that we can answer that question, a norm being a certain kind of reason for action on this view. And indeed, it might be asked, well, how could something be my guide without it being a reason for me? How can the law guide my action, my behavior, without giving me reason? Well, you can use the law as your guide, you will use the law as your guide, provided that you have reason. But this does not imply that itself the law is your reason. Okay, second, obligations. So the second aspect of the non-positivist challenge, Les thinks we should take more seriously, and this is our need to explain how law imposes obligations. Now, it's worth recognizing that the capacity to impose obligations is not a formal property that follows from law being composed of rules or norms. We have rules of monopoly, but no monopoly obligations. We have rules of language, but no obligations of English. Law, on the other hand, does sound out in obligations. So in the chapter, Les criticizes a range of explanations of how law imposes obligations, sanction-based accounts, social pressure-based accounts, before settling on his own view, which treats obligations as a structured set of reasons. So a norm, Les says, is obligatory only if it offers a reason for acting as it requires and a reason for not acting on certain valid reasons to the contrary. Now, one reason we might have for being skeptical about this account is if we do not think of rules themselves as reasons. But I want to consider a further objection here, and this is that this fails as a general account, in part because it can't make sense of some of our most obvious moral obligations. So a preliminary point here, well, why should we be thinking about moral obligations when Les is here talking about legal obligations? Well, I take it that Les is trying to offer an account of obligations such that they can take the modifiers, legal and moral. And as a general account, I think it can be called into question by examples from either domain. So consider a paradigm case of a moral obligation. The obligation to save a drowning baby in the case of easy rescue. Now, certainly I have reason to do this. Indeed, I have overwhelming reason to do this. It's my moral obligation to save that child. On the protected reasons account, however, I only fulfill this obligation if I A, act on my very important reason to save the child, but also B, disregard or refuse to consider certain reasons to act otherwise, these being the reasons that are excluded by the obligation. Now, it's certainly true that my reasons to save the child would overwhelm any reasons that I have to do other things, to go to lunch or to listen to my favorite album. But it doesn't seem to require me to disregard these as valid reasons. They're simply overwhelmed by my overriding reason to save the child. Now, stopping in front of the drowning child to consider the worth of my lunch date or the aesthetic pleasure of my favorite album, well, that would be perverse. Instead, as soon as I recognize that the child is drowning, I should act. The consideration, once raised, is indeed decisive. But decisiveness, the decisiveness of the consideration, is different from it excluding other considerations. Indeed, according to the account that Les favors, if I take an overall view of the reasons that apply to me in this situation, rather than excluding some from consideration, I may have saved the baby, but I will have failed in my obligation to it. And this strikes me as counterintuitive. How then to think of obligation in this case? Well, it's a moral obligation as opposed to a mere moral reason because it decisively overwhelms all other considerations, both actual and hypothetical, personal and interpersonal, rendering the conduct contained in the relevant obligation compulsory for me. It's a consideration that, once raised, overwhelms all other options. And this means that our moral obligations are always and only the most important moral requirements that apply to us. Well, what of law? Law is a system of compulsory control. Its norms apply to us and hence are supposed to conclusively determine our behavior simply by virtue of our satisfying their conditions for application. But these requirements, unlike the requirements of moral obligations, can be bought cheaply, simply through the exercise of ordinary human agency in the authoritative creation of rules. They are obligatory because enacted, affirmed. So morality imposes obligations on us only when it really matters. Law imposes obligations whenever it is decided it does. This, I think, is a sobering fact about law and an important consequence of its positivity. All right, thanks.
Thanks, Julie, Nicos, and Tom. And now we want to hear from you, Les, but also I want to thank, I forgot to thank the people that actually that came online. We have around 60 people, so thank you all for joining. Les, please, the floor is yours.
Thanks so much. I won't talk too long, but thanks also to Julie and Nicos and Tom, and I miss all of you. In fact, I missed that room. As I look around, I think, gosh, I sat there a mere 40 years ago for the first time. And here we are again. So these are all very rich comments, and I'm only going to say very little. I'm curious to hear what people whose views are unpredictable might have to say about it. But let me say something about Julie, first of all. Julie, you may have noticed, I hope you haven't failed to notice, that our discussion those years ago, not the one about tomatoes, but the one about problems, changed my mind. And changed my mind as a result of your writing and argument that day. So yes, I do think jurisprudence can progress by finding questions that we hadn't thought of, questions that need answers. I just want to point out one thing about the logic of questions and answers. If you think that jurisprudence progresses when it does, by getting better answers, you're committed to thinking that it has questions. Because question and answer are a relational term. And if you have an answer, necessarily there's a question. But the converse is not true. We can find a question to which we have no answer. Or maybe a question to which, and I'll come to something Tom said now, to which it's not sensible to look for an answer. So I agree with that, and I didn't think of that on the day you recall. And partly as a result of your argument, and then I think in the book I gave an example of something that John Gardner brought to mind, which again I had never considered. And maybe some of you haven't. It's a beautiful essay, John's. How could there be a written constitution? And I had never considered that as a question. Like most people, I wondered how there could be an unwritten constitution. So I think that was progress. I suppose we want to specify it more narrowly and see if we get progress when we get sensible questions or useful questions, or maybe even just questions that we could answer with the tools that we have. And so one of the reasons I think jurisprudence, philosophy in general, but I haven't argued that, jurisprudence progresses by shrinking, by stopping attending to things it can't do, is that jurisprudence can't give sensible answers to questions like, should we have judicial review, and so forth. Right? These questions are more in political philosophy, general jurisprudence. So Julie, you changed my mind, and not for the only time. A close reading of the book will show up other places, including in chapter 3, where you affected the way I think about things. Nicos. Now, Nicos and I disagree on so many things. It's like shooting fish in a barrel, not in the sense that they're easy to apply to, but in the sense that there's so many of them jammed into the barrel that anywhere I shoot, I'm going to hit something. So I'm going to do something very, very simple. Nicos says the point and purpose of law, we might talk about that, is to constrain government power. I find that baffling, both to think the law has a point and purpose, and that that's what it is. So even state law, we know, has lots of positive and not really restrictive functions. And it has many of them that have nothing to do with anyone's coercion, never mind state coercion. We could talk more about the US Code, but have a look at the Irish Constitution for a bunch of important non-justiciable norms that are legal norms in Ireland. But I have a simpler example, Nicos, and we don't have to consult our Irish colleagues on this. Canon law is a central case for the legal system. Central case, not a border-coming case. And canon law does not restrict the powers of any government and does not purport to do so. So I don't know where I do know where you come up with this, but it's a very, very puzzling and emaciated view of what state law is. And it can't even come close to explaining other clear cases of legal systems. Tom, this is complicated, as I guess everything is. Tom and Nicos are sometimes misled by the fact that I help myself to parts of Raz's apparatus and his nomenclature. But I'm afraid to say, I think I'm probably second to no one in my admiration for Raz. I disagree with him on a whole bunch of things, including the definition of a norm. The relation between norms and reasons, I also disagree with Parfit and that, and on the relationship between reasons and obligations. So I don't want to have to defend someone's view with which I disagree. But I see how, as soon as someone says, a reason not to act on, someone will say, aha, you're committed to this, and bring out the Raz type objections. But I think, I don't want to go too far down this path, but some ways I think Raz has the order of an explanation between reasons and norms backwards, because I think norms are a kind of reason, and reasons are a kind of norm. Now, there's one very interesting thing you said just in passing, that my definition of norm would struggle with belief, theoretical norms, I guess. And I don't want to commit to doxastic voluntarism, as the philosophers call it. I'm not sure that we can choose what we believe, but we can be guided whether or not we choose it. The guidance can come in other ways. I sometimes wonder, all of us in this room, I hope, think one shouldn't assert contradictory propositions, right? We spend all of our time trying to hunt them down in people's articles. He asserted P and not P. But whether or not that's a good norm, I'm interested in the question of whether you can believe contradictory propositions. And that's a different question. Nozick makes his point in several places. And in fact, Nozick comes to the conclusion that there's no really good reason for the rule never entertain contradictory propositions. And one reason for that rule is that we very often don't know which of the contradictories is correct or assertable. So we might want to just have a kind of distant, non-committal attitude towards contradictories. That might be a better rule than sitting there thinking, oh gosh, I asserted P and not P. Which is it? Maybe you should just say, I don't know. We'll just have to go with that. But you might not want to write it down in your thesis because you could get into trouble with that. I would like to leave, Tom, for the general discussion, your kind of Aristotelian view that when I grasp an obligation, straight where I act. That's a quotation from Life in Nicaean Ethics. I have reservations about that. But I think maybe they are too narrow for kind of general interest. So there are lots of people here I know, and it's great to see you. But there are many more people that I don't know, and I would like to get to know you. So why don't we open it up for a discussion and comment? And don't feel you have to have I forgot how Julie put it, whiz bang, knock down objections. You just ask a perfectly reasonable question. What does this mean or something? It's perfectly fine.